I want to bring you to two more words that are in debate right now from the preamble, which is socialism and secularism. And the debate is to remove these two words.
That's why the wisdom of the Constituent Assembly, which I can't appreciate enough. They said the state shall endeavor to bring about the UCC in the entire country, including J&K.
But what about the newer kind of challenges like environment, like artificial intelligence? How will the Constitution evolve to face these kind of challenges?
And I feel very proud we have a country which is far, far ahead of the so-called advanced countries. This is how a living constitution evolves to absorb the challenges, meet the challenges and proceed forward.
So recently our Chief Justice also said that our constitution is a quiet revolution etched in ink, and it has protected our country in several crises.
I come from Andhra. I remember N.T. Ramarao with huge mandate. He comes and somebody here tells the governor there, dismiss him, create a split. Split. Not even a split, a fringe goes away and then you dismiss him, and then of course he's been restored because there is a lot of civil society action. Yeah, a lot of things we didn't have at the inception. And it's not that the members of the Constituent Assembly were all knowing, all seeing, omniscient. No. That's why you have Article 368. That is why you have a flexible method of amending the Constitution. They were telling people, don't sell liquor within a radius of 500 meters from the highway. Yeah? Then you change the name of the highway and start selling, which is what Punjab government did. And people were saying, what is a highway unless you are high?
हेलो एंड नमस्ते, मेरा नाम है डॉक्टर दीपान्विता और आपका स्वागत है इस कन्वर्सेशन पे। आज हम एक बहुत ही महत्वपूर्ण टॉपिक पे डिस्कस करने वाले हैं, एक ऐसे इमोशन पे डिस्कस करने वाले हैं जो आजकल काफ़ी न्यूज़ में है, द इंडियन कॉन्स्टिट्यूशन या भारतीय संविधान। अगर इसका डिस्क्रिप्शन देखा जाए तो इट इज़ नॉट जस्ट अ लीगल डॉक्यूमेंट, it is actually the voice of our democracy. It is the voice of the collective will. It is the root or the foundation of our identity, and it is much, much beyond that. तो जब हम बात करते हैं ना ये कॉन्स्टिट्यूशन के बारे में, या ये जो आजकल डिबेट्स चल रही हैं, चाहे वो जो दो वर्ड्स पे, प्रियम्बल के दो वर्ड्स पे डिस्कशन चल रही हैं, या बेसिक स्ट्रक्चर डॉक्ट्रिन के रेलेवेंस पे डिबेट्स चल रही हैं, कहीं ना कहीं हम ना बेसिक्स को खो जाते हैं या बेसिक्स पे हम फोकस ही नहीं करते हैं। तो आज इस पर्टिकुलर पॉडकास्ट में हम इसी चीज़ पे फोकस करने वाले हैं, हम स्पिरिट ऑफ कॉन्स्टिट्यूशनलिज्म पे फोकस करने वाले हैं। और आज हमारे साथ हैं श्रीराम सर। सर, who needs, there are, as I always maintain, there are certain individuals, certain stalwarts who don't need an introduction. Shriram sir is, every student, every aspirant, whoever has been mentored by him, has studied his books, has taken his lectures, they know his depth of the knowledge. Today, we are going to discuss on the Indian Constitution, and sir, welcome to this podcast.
Thank you so much.
So the first question comes from a recent debate in which jurist Farina Riman was asked, what is this enduring quality of the Indian Constitution that makes it relevant even today?
You see, Indian Constitution has everything for everyone in India. And that's not come about overnight. It was drafted by the Constituent Assembly sitting from late 46 to late 49, and so many committees and subcommittees under the wisdom of Dr. Ambedkar, Dr. Rajendra Prasad and so on. So yes, we have borrowed from every major country, not just major country, even minor countries. We borrowed from UK, from USA, from Canada, from South Africa, from Australia, and from France and Germany and so many other countries. Even Japan we borrowed from. So when you have a freedom struggle involving everyone in the country, led by millennial leaders like Nehru and Mahatma Gandhi, their intention is to ensure that when freedom came, we have a document based on which we will bring up a country which is all inclusive. They are free, they are prosperous, they have lots of rights, and the state has obligations given in the constitution itself, according to which good governance is provided. Even they spoke of foreign policy that pursues the ideals of security, peace, and whatnot. So, with so many aspects which are not there in a constitution anywhere else that are built into our constitution, you are bound to have the document enduring, not just enduring, but also enlivening. So it's no wonder that if you followed the freedom struggle, if you followed the Constituent Assembly debates, then it's no wonder that you have a constitution which is the hope for everything for everyone in the country, not just individually, social groups, yeah, for the whole nation. Yes.
So when it was so inclusive, a lot of questions comes that there is more focus on flexibility because of the numerous amendments that have come in. Is that when we see the Indian Constitution, we sometimes say it's a perfect balance of rigidity and flexibility. But there is also the idea that it's constantly trying to address challenges. In that light, sir, what would you say? Is it a perfect balance or is it more flexible to be more inclusive?
That's Article 368. It's a combination of flexibility and rigidity. We'll come to definitions and the rationale a little later. Go back to 1951. You started governing. The Constitution came into force 26th of November 49 and effectively, yes, the Republic Day of 1950. And we had a country that had been so badly distorted, destroyed by the imperial powers, we had to rebuild. And rebuild not mechanically, rebuild according to the most sincere and wild dreams of our people, the most disempowered people. And so what happened? The very first Amendment Act, if you go back to Champakam Dorai Rajan, in Tamil Nadu, then it was Madras, state of Madras, there was a GO, slice all the seats in the professional colleges and distribute them according to the caste. And she belonged to a caste, Brahmin caste, and she didn't like it because, maybe she was driven by merit, maybe she thought caste is divisive, maybe she thought she was deprived. So she goes to the court. And the court goes into Article 29, wherein you're promised equality irrespective of race, religion, caste or language. They latch on to that, rightly or wrongly, that's another matter. And based on that, they struck down the reservation order of the government of Madras. Then Nehru had to step in to amend the constitution to provide for reservation. And then the Supreme Court and High Courts were supporting the left and the right on both the extremes. And in the process, Article 19 was found wanting according to Nehru. He had to amend the constitution, Article 19.2, the basis for imposing reasonable restrictions. He brought in public order, friendly relations with foreign countries, and also incitement to an offense. So 19.1 got restricted. And then you see, what did you have when you got independence? Steep inequality, mass landlessness. And there you have the DPSP Article 38, 39 promising social, political, economic justice, prevention of concentration of wealth and distribution of material resources for the benefit of everyone. So Nehru had to amend the constitution, bring in 31A, 31B, the 9th schedule, ensuring that when you distribute the land after taking possession of them from people with surplus land, this distribution, even if it hits your Article 19, Article 14, at that point Article 31, nobody should be able to go to the court. All these amendments, put into one single amendment of course, had to be done right after the constitution kicked in. So you could count from there, even while. That is why flexibility is a prominent part of Article 368 rather than rigidity. Rigidity is what? Parliament initiates, passes, sends it to the states, and at least half the states have to ratify. Only then it will go to the president, and the president, of course, has to sign Amendment 24, 1971. Flexibility because they knew the challenges were just too many, and therefore, even with a double majority, which is what you call special majority, Parliament should be able to do it, and states need not come in for every amendment. So flexibility helped you amend the constitution this many times, 106. Otherwise, where are you? There is no anti-defection law. There is quite a lot of things that you have in the constitution take for granted. They won't be possible unless you have the states excluded from the amendment process. So it's tremendous wisdom and far-sightedness on the part of the makers of the constitution in the assembly that gave you a combination of flexibility and rigidity. Enormous wisdom, enormous wisdom. Can't appreciate it, can't admire it enough.
That's true. So I would want to come to certain basic terms. Like, for example, you use the word reasonable restriction. And students in my class always have this, a problem to understand who decides it's reasonable and why put this kind of restriction.
You know, you won't believe if I tell you, at the outset of the constitution, the word reasonable was missing. It was brought in by Nehru in the First Amendment Act.
That's what I was coming to, sir.
Yes, so reasonable. Reasonable means what? Right is the norm, restriction is the exception. So you must never squeeze the right out to a point where, the victims feel that it is unnecessary. So an ordinary person, how does he see a restriction? For example, internet shut down. Jammu Kashmir, 2019. There's a lady called Anuradha Bhashin. She was a journalist. She goes to the Supreme Court saying, "Sir, my freedom of speech, I'm a journalist. Sir, my neighbor does business, Article 19(1)(g). We make a living out of freedom of speech and Article 19(1)(g), the profession, business and so on. Shut down the internet for internal security and other matters, no problem. But don't shut it down beyond what is necessary. Don't be disproportionate in your suppression of the right. Do suppress the right. For example, go to Bihar, you can't drink in Bihar. Yes? But then if somebody drank, he can't be executed. There can't life imprisonment if you drank. So please invoke a DPSP, enforce prohibition, but don't punish the person who drinks to a point where the restriction becomes unreasonable, asymmetric. So that is reasonable restriction, which means that it shouldn't be disproportionate, it shouldn't be excessive, that much of restriction which is necessary to ensure that the exercise of the freedom is balanced with the goals that you have set for yourself. For example, right now, old Rajendra Nagar, if there's a bit of a problem, then what can you do? Curfew, this, that you can have, but not forever, not for a week. You could have for a few hours. Problem is big, you could control the metro a little bit. But then not for a second longer than necessary. That is reasonable.
But so who decides on it? Because students will keep asking me this question. Who decides? Because I could say it is reasonable for me, but you could also say, no, it is not reasonable. So who then comes with the power to decide that?
So there is, at one level, executive, the DM and all that. And that is based upon the law made by the parliament, the state legislature. And if neither of that is satisfactory, go to the High Court, go to the Supreme Court, and they will apply the time-tested criteria
based on which either they'll endorse the perception of reasonableness on the part of the executive and the legislature, or they will add their own criteria and ensure that due process is expanded.
So let me come down to another word that you had said, which is social justice. It is a theme that runs throughout our constitution. So could you just elaborate what it means in the context of India when we say that the constitution has social justice and has asked or guided the government to work on this?
Preamble says we give you justice, social, political, economic.
Right, sir.
DPSP Article 38 is full of social, economic, political justice. Rest of DPSPs are the flesh and blood of social justice. So what is social justice? Social is groups, men, women, rich, poor, ethnicity, race, tribe, language, religion. All of them are the identities for formation of a group. So there has to be, what is justice? Justice is fairness. Men and women, as much as possible, equal. A woman deserves maternity relief. No one argues with that. And caste inequality cannot be tolerated. All castes are equal. So, social justice is ensuring that all groups are treated equally, number one. All groups benefit equally from the progress of the country, number two. This is social justice. Social is identification of the criteria for seeing groups. Economics ensures that material justice is done. Political justice would be enabling them to have a vote irrespective of all else. If you are 18, irrespective of everything else, except extreme exceptions, you are entitled to vote. You are entitled to go for UPSC. So lots of rights associated with the government are political. Social is gender, race, etc. Economics is material. Yeah.
Right, sir. So from this slide, I want to bring you to two more words that are in debate right now from the preamble, which is socialism and secularism. And the debate is to remove these two words. So could you just, before we get to the debate, I would want you to elaborate the meaning of these two words in light of the Indian Constitution. Because if you read it outside the Constitution, these two words have a very different meaning. Secularism could be Western secularism. Socialism could mean, from the perspective of a different understanding. But when you put it into the preamble, it reads it differently. So could you elaborate on that?
Socialism, if you go into the Oxford Dictionary of Economics, would mean what? Public ownership of means of production, land, labor, capital and enterprise held by the state in public hands is socialism. That's supposedly meant to bring down inequality, ensure growth benefits everyone. That is a dictionary meaning. But in our constitution, when you have so many DPSPs and affirmative action and elimination of child labor, all that, whatever is good for society by way of ensuring the inequality is brought down and empowerment and mass takes place, that we call socialism. And in our context, you should classically call it socialist pattern of society. It's not socialism as a doctrine like Marxist and Maoist and all that. Socialist pattern of society is nothing but what your DPSPs and a sprinkling of your fundamental rights prescribe. That is socialist pattern of society. Your next question would be, why did we not have it at the inception? Why did we import it? Why did we induct it in 1976? Yeah, a lot of things we didn't have at the inception. And it's not that the members of the Constituent Assembly were all knowing, all seeing, omniscient. No. That's why you have Article 368. That is why you have a flexible method of amending the Constitution. And in 1976, the Parliament thought that 42nd Amendment Act must be done so as to keep these two words in the preamble. What's wrong? You are erring on the right side. What's wrong about it? It's not that all private enterprises are confiscated by the government because the word preamble figures in the, the word socialist figures in the preamble. No. We are LPGing our economy. Liberalization, privatization, all these things are going on. But at the same time, tomorrow if somebody asks the Prime Minister, sir, why are you unleashing so many welfare schemes on the country? He can tell you we are a socialist country. We are a welfare state. So for all practical purposes, you could say socialism in the context of India is welfare state. Nothing more, nothing less. But add to that a little if you can. Socialism and welfare state differ in one very important dimension, which is under socialism, government can own a part of the economy. In welfare state, it may not be able to own. If the welfare state happens to be under the umbrella of the preambular expression socialist, then the government with all the might in the world can nationalize and get away. Keep industries in state control and ownership and get away. But if the word is not there, then tomorrow you will go to the Supreme Court, sir, we are not socialist. We are only a welfare state thanks to DPSP. So denationalize all the industries. Why should we have the railways in the hands of the government? Even DRDO, nuclear power, space, denationalize all that. Then the Supreme Court will be constrained to say the state has no constitutional basis for economic ownership, and going by the letter of the Constitution, even who knows, spirit of the Constitution also, you get out of economy, ownership of economy. And come to the word secular. Secular is what? You see, we are not going into the metaphysical, philosophical meaning of secular. For us, secular means the government will not have an official religion, won't sponsor any religion, won't deny equality to religions, and everyone, citizens and others, they are free to pray to whoever they like, not pray, wait till they discover God and then pray. So, you have the right to your religion, subject to, of course. And the state and the religion, their relation is categorical under the rubric of secularism. And yeah, that's what secularism is. And it's important that we say it in the preamble because nowhere in the constitution outside the preamble it is said that the state will not sponsor a religion. Where is it said? It's not said anywhere. States should not have an official religion. Where is it said? It's not said. Indirectly you can't go legally by quoting something which is indirect. State doesn't have an official religion. It has to be said, which is what the core of secularism is. State and religion are separated. But you were talking about the Western notion of secularism as in India, religious symbols can be worn in public. Karnataka case is an exception where for a brief while you are within the classroom, you cannot wear, etc. Otherwise, on the road, my personal pleasure quite often is seeing, Sikhs, Muslims, all of them flaunt their religious symbols and we are enjoying our diversity, and that's the ultimate thrill in social life. And that you don't have in France, in Switzerland and elsewhere, where they are very cagey about religion. They don't allow you to wear your religious, symbols and all that upon you in public, areas, etc. So we are great. That's because for 3,000 years, our DNA shouts, live and let live. Whereas they have been growing up of late and they are trial error, 2 steps forward, 1 step back. Whereas we've done all that. We committed all the mistakes. And we are robust, resilient in our openness. Yeah.
Right, sir. And I think, the way you explain the basic of those words, I think that is missing in today's debate. So the leading media, the traditional media, the debates that they're having, they're talking about ideas which have been imposed or interpreted with this basic. If you don't understand the core word and why it was added, you are missing the spirit of the entire thing and you're just debating on the air. Coming back to another word, sir, another phrase, the Indian Constitution is called a living document. Sir, in what light do we call that?
There are 2 schools of thought. One is the originalist, the other is the school of living tree. Originalist is freeze the Constitution as it stood and don't change it unless it's absolutely necessary and so on. Whereas the living tree school says that Constitution, after being drafted, comes across a variety of situations, challenging the Constitution to respond meaningfully and effectively, and so it should evolve with times. For example, I'll tell you, the very first Constitution Amendment Act, Constitution to be living, had to accommodate those changes so that affirmative action is there in our public policy, so that there is land redistribution. Now you please come to the latest living document, ours is. The other day Supreme Court gave a verdict. Supreme Court can give any verdict that you may not find in the Constitution, but that is a part of Constitution. You call it constitutional law. I'll go back again to Anuradha Bhasin case of 2020. And also, there is a Amar Jain verdict of 2025. There are people who are challenged. There are people who are normal. And both of them are subjected to digital governance, e-governance. Lots of benefits come to you because of digital access. They don't have. If I'm visually challenged, what can I see on the e-Shram portal? I can't see in the Shram portal. So, but the person who is next to me, he is not visually challenged. He has access to the benefit, he is enjoying them. But both of us are equal, Article 14. Both of us have the same right to life, Article 21. Therefore, the Honorable Supreme Court said that all the challenged people should have equal access to the digital governance route. screen reader you keep, whatever else you keep, ensure that they don't miss out on anything. Similarly, that is, Constitution evolved to accommodate the digital governance. By Supreme Court ruling, you could make a law, but you need not amend the Constitution for that as of now. Anuradha Bhasin, the Supreme Court expanded the rights to make sure that all the rights you exercise on ground are equally accessible on internet, right to internet. So, the rights that you have on 19, exercise them via the net also. This is how Constitution, anti-defection law. It's another thing, it's not functioning of late, except in era. But anti-defection law ensures political morality. That wasn't there till 1985. So our constitution rose to the occasion. Panchayati Raj and Nagara Palika, constitutional status, 1992, by Parliament amending, getting the states to ratify. If not for Panchayat and Nagara Palika, decentralization, women reservation, OBC reservation, SC reservation, ST reservation, so much of developmental responsibility conferred on these two institutions, we can never get rid of extremists. Today, when the Government of India, Ministry of Home Affairs says that we'll get rid of Naxalites by the 31st of March 2026, their conviction is we are giving everything to people in these states which are extremist infested, and we are confident that they are happy with what we are giving, and they are confident by their participation will improve the standard of living. They don't have to give an inch of support to the extremists. So, Constitution rose to the occasion, 73, 74, anti-defection, and the 42nd Amendment Act destroyed. It mini Constitution, which has the tail wag the dog, etc., etc. 44 came, ensured that imposition and continuation of emergency, and even while it is imposed and continued, rights are protected. 20 and 21, 44th Amendment Act. This is solid, and there are a lot of people, some people disagree with me, they are called the EWS. I see them very happy, you must be also. They are very happy in the classroom. Earlier they had no chance, today they have a chance. They are making it to the bureaucracy, they are very happy. And it's okay that they are economically weak, they require a corner in the government, they require the government to be concessional to them. So the constitution was amended to make sure that they have access preferential. SC, ST, OBC, we have to do. EWS, constitution found it fit to do. And that is how constitution evolved. Women, after this census, delimitation, I think we'll come to that topic also. Women will have 33% of the seats in Lok Sabha and assemblies. How long have they been deprived, delayed, misled? Yes, and humiliated effectively. Today, 1/3 of Lok Sabha and assemblies are women, and I feel very proud we have a country which is far, far ahead of the so-called advanced countries. This is how a living constitution evolves to absorb the challenges, meet the challenges, and proceed forward. GST. You were having all sorts of indirect taxes, state taxes, central taxes, tax on tax, cascading. And 101 says one single nationwide consumption-based tax. And they're doing so well. Last month the GST collections were 2 lakh crores of rupees. In a separate debate we can dissect the number. But the point remains, GST was long overdue. Finally, you brought it in about 10 years back, 2017. So this is what you mean by living constitution, to ensure that, all the ideals of the constitution are implemented. Yeah.
Right, sir. So recently, our Chief Justice also said that our constitution is a quiet revolution etched in ink, and it has protected our country in several crises. So right now we talked about, you touched upon several crises, several important things that the constitution stepped up to give honor to various sections of the society. But what about the newer kind of challenges like environment, like artificial intelligence? How will the constitution evolve to face these kind of challenges, especially in the light of the fast movement of these crises?
Our constitution has tremendous room for reform. But these reforms are not necessarily by amending the constitution. You talked about the environmental crisis. You know, last year the Supreme Court gave a verdict. Supreme Court has been for the last approximately 30 years giving verdicts which are, pushing the country towards environmental stability and so on. MC Mehta cases, they're all about, you have your Article 21 expanded, right to life includes the right to clean surroundings. And the High Court of Uttarakhand, Punjab and Haryana, what did they say? They said that a river or a hill is a person according to Article 21 and they have their rights not to be polluted. So you have expanded the meaning of person in Article 21. You have ensured that Article 21 is expanded to right to life includes the right to clean surroundings. Last year, Supreme Court said, some people are so vulnerable that greenhouse effect, the global warming hits them harder. That violates Article 14, which is equality. So we have, according to the right to equality under 14, everyone has a right against the adverse impact of climate change, whatever it means. Water conservation, adaptation, afforestation. Kusum, they have a scheme called Kusum, where you use solar energy for your irrigation purpose. You can even sell a little solar energy if you can produce that much more. So, the Ranjit Singh verdict it is called. 2024, Supreme Court gave this super verdict. Whereas, that is how judiciary is equipping India to deal with the environmental crisis. Similarly, you talked about artificial intelligence. AI is about 3 years old. I remember first hearing about ChatGPT, November 2022. My daughter told me, she's into advertising and designing and all that. She had told me the ChatGPT is, something I can't express in my own words. It's so good, creativity, etc. I got into it, plumbed into it from March 2023, which is about 2 years plus. And it's already there in the courts. The Delhi High Court said that Amitabh Bachchan, Jackie Shroff, Anil Kapoor, Sadhguru, all of them have personality rights. Deep fakes using their personality, memes using their personality. They should have the control over how their, voice or looks or anything else is used or not used. So they have the rights over their personality, whether when it's commercially used, they should be able to say go ahead or don't go ahead. So that's already come into jurisprudence. Judges are already using ChatGPT, at times hallucinated. Lawyers are using it. So how do we deal with this? Copyright is used. The other day, a court in America ruled that Claude, which is an AI just like OpenAI, you have written a book, super book you have written about international relations. PDF is available. That is fed into the information that these AI people process, what you call, training or scraping or whatever you like to call. And I ask, tell me about how our foreign policy should be formulated in the light of, Pakistan, America getting close and Bangladesh, Pakistan, China getting close. How should we recast our foreign policy for greater security? You have handled it in a chapter in your book because you wrote it in the middle of 25. That has already been processed by OpenAI. They'll give me a summary of what you said. Not just you. Somebody else studied with you in JNU and she also wrote a book. Specifically India, Eurasia. They got that also because nothing can stop them. They have no barriers. So my answer is not just you. You and another scholar combined. Now you go to the court. The court in America said it is fair use. They have not copied. Copyright is what nobody should copy for commercial purposes other than you or the one authorized by you. But they have not copied. We have made fair use of your intellectual contribution. So, that's another. So, copyright law is in the legal corridors now, copyright. And there is one news agency which has been commented upon in an entry in Wikipedia. Delhi High Court said, I told Wikipedia, take it down. Supreme Court said, how can you ask them to take it down? Freedom of speech, 19(1)(a). Let 100 flowers bloom. We are here because everyone spoke. Don't clamp down unnecessarily. What have they done? The Article 19(1)(a) is not just to do puja. It is to criticize also. Criticism is the lifeblood of democracy. Supreme Court took off. So AI is already in the crosshairs of the Constitution and the courts at the highest level. Yeah.
Right, sir.
And it's coming in the exam, I think.
Yes, sir.
Well, thank you.
Sir, coming back to fundamental rights, because we have been talking about certain major fundamental rights, I wanted to talk actually about a recommendation given by the NCRW. And one of the core ones said that in Article 15 and 16, prohibition against discrimination should be extended to ethnic or social origin, political or other opinion, property or birth. So what is your opinion on this particular statement?
So let's recount basically what is 15, what is 16.
Yes, sir.
In India, across history, access to public places was restricted. We are ashamed of a historical fact called untouchability. And that extends to women also. A lot of public places were shut out for women, untouched, this and that. So Article 15 is an answer to that, constitutionally guaranteed. No one can be shut out of a public place like hotel or a restaurant or a shop or a hospital, school, road, ghat, etc. What are the criteria? Religion, race, caste, sex, place of birth. Because these are the basis on which exclusion took place. So you are quoting to me NCRWC recommendation that the basis on which exclusion should not take place should be expanded. But then you are talking of ethnic. Religion is ethnic. Race is the core of ethnicity. Race is ethnic. And then you got caste, which is ethnic. What else is ethnic? A tribe is ethnic. Tribe again is based possibly on race also. Religion, race, caste, sex, place of birth. So only gender and place of birth are not ethnic, but gender is social. The core of social is gender. But then you see, I recall an incident, a book launch in Chennai, about say 10 years back, 8 years back. A serving High Court judge in the state dress of Tamil Nadu, which is, lungi and vesti. He came on a Sunday to a cricket club to launch a book, not his own, not his friends or relatives, somebody else's. And the security at the club told him, you can't enter because you are in Tamil dress and you need to be suited, booted, etc. And being a man of, judge, he didn't argue because he enforces law. That's law. Article 15 doesn't disallow that. Article 15 doesn't disallow you. A dress code is allowed. And so he went back. But the chief minister, the lady Jayalalitha, got furious about it. Legislators got furious about it. It is like a suit and a boot disallowed in UK. Tamil dress, which is a product of history, circumstances, all that, that's been disallowed. It's not you or I, it is a serving High Court judge. So she made law saying that all the dress code rules in every public place in TN have to be reformulated to ensure that this dress should under all circumstances be allowed. So you see, you want to include that, but then there's a judicial ruling. And think of transgenders. In 2014, National Legal Services Authority, which is Supreme Court, they challenged the Union of India, and in that challenge, the Supreme Court gave a verdict saying transgenders are the third gender. That is their identity. And you should have toilets, this, that for them. And follow it up with reservation for them. Enormous. So, and you know this, that women can go into that Sabarimalai temple. If you disallow them, it constitutes untouchability. Rama's verdict. And transgenders, LGBT, homosexuality was a crime till the other day, 2018. And if you read the original verdict of the Supreme Court given by two honorable judges, it reeked of bias like generally you don't find in a judicial ruling of that class. And so there's a curative petition, Article 136. People went there and in an open court, Navtej verdict was delivered in 2018. 377 of IPC decriminalized. So that is linked with 15 also. So 15 saw enormous expansion, not necessarily ethnic, not necessarily social, but women, all that they enjoy today. Tomorrow you go to the court saying on what basis did you give 33% to women? Article 15. All that women enjoy, education, jobs, representation, maternity relief, all, maternity relief, Article 42 is a DPSP, non-enforceable, non-justiciable. But 15, you can shower all the benefits on women. 15 will give you constitutional support. So R15, I'm proud of it. We are what we are because of 15. And 15 and 16 are sisters. 16 is for jobs and 15 is for public places. So both of them have done tremendous service to nation building in the country, social justice in the country, and we need to be genuinely proud, be proud of that. EWS, 15, 16, yeah.
So coming back to again the NCRW, the core recommendations, and now I'm going to come in light of the sedition discussions going on. So it notes that the freedom of speech and expression should be expanded to the freedom of press and other media, freedom to hold opinions and to seek, receive, impart information. So in that light, sir, do you think recommendation is really important because of the debates going on?
That was in 2002. After that, we have the right to information.
Right, sir.
Which is based upon Article 19. So you have the right to information flowing from your 19, and from day one it's been abundantly recognized that the implied right of Article 19(1)(a), you have the freedom of speech. You and I can start a channel. So freedom of speech implies very categorically freedom of press. And top that with 19(1)(g) business. I want to start a channel. You and I, we have opinions, we have information, we are educated, we are energetic. We can start a channel. 19(1)(a) gives us freedom of speech. 19(1)(g) gives us freedom to do business. And both of them are very clear. Freedom of press is everywhere a derivative of freedom of speech and freedom to do business. So I think it should be in all dignity, in all enlightenment, left to be read into Article 19 rather than being spelt out. What are you missing for the right not being spelt out formally? You're not missing anything. India celebrates freedom on a second-to-second basis. If you missed your Twitter, that is X, for half an hour, you have so many things, so much of entertainment you missed, so much of venom you missed.
Right. So shouldn't then RTI be given constitutional status if it's that important?
But how does it matter if you have it either as a statute or as a constitutional provision? It doesn't matter. Take Interstate Council. When did you hear of Interstate Council? Constitutional body, Article 263. And then think of other statutory bodies. Think of Governing Council of Niti Aayog. It doesn't even have a statutory status, not set up by an act of the parliament, but it's everywhere, the most powerful body in planning and nation building. So constitutional status may not mean anything at all unless you invest it with a lot of public faith and utility.
Right, sir. So coming back to the core recommendation. So one of the other core recommendation was to add population control as DPSP. In the light of what's happening, where we are with the population really booming, should we really do that?
Population control is taking place. You see, basically, Mrs. Gandhi said, after she came back in 1980, development is the best contraceptive. Ask Andhra Pradesh, Tamil Nadu. Andhra Pradesh, they are incentivizing people to reproduce. People are saying, no, we can't afford. One child is a luxury. Sending to school, teaching, you must be knowing it, teaching, taking care. And one child is wonderful, I'll make them into send them to LSR and JNU, this and that. I can entertain my dream for a child beyond which it's above my pay grade. So you cannot, population control takes place by development, which is what's going on in the country. So the organic logic of development is taking care of population stabilization. And to say that was 2002, by when it wasn't realized that population also can be considered as an asset, which is what Indian young people are, public good for the world. We can uplift the entire world. That's the nature of our young people. Our young people are, mesmerizingly talented and so on. We can, help the entire world. So I think that's outdated.
Sir, coming to the DPSP then. Is it relevant as a guideline today? Because when it was given when it was added to the constitution, it was seen as something that later on the government is going to work on these parameters when the time is right, when the circumstances are right. But we have been seeing that, like for example, UCC and other things which are there in the DPSP has become a political matter rather than something which is being carried out. In this light, should then DPSP, or should we see it as losing its relevance?
First, I'll talk of UCC,
Yes.
then I'll talk of the DPSPs as the chapter. UCC, if you read the words which you find in Article 44, the state shall endeavour. UCC can't be imposed, which will make it inflammatory and divisive, and that will be counterproductive. That's why the wisdom of the Constituent Assembly, which I can't appreciate enough, they said the state shall endeavour to bring about the UCC in the entire country, including J&K. J&K is a part of India, for God's sake, including J&K. So that's a separate matter. So UCC, but we already have a UCC in the country. So many judicial rulings are there. So many amendments of the statute by the parliament and the state legislatures. We effectively have a UCC, but being left to evolution through judicial and legislative pushes is better than taking up a jumbo UCC law. So keeping it as a DPSP is very important, because if you make the DPSP justiciable, none of the DPSPs will be able to go through without counterproductive, self-defeating, erosive effect. So take any DPSP and how can it be justiciable? It's not justiciable. So they are constant reminders of the Constitution to the people in power that you have an obligation. You have a, these are based on conscience. We want to set a date for that. But please ensure, for example, prohibition in Bihar, driven by a DPSP. Can't eat beef, driven by DPSP. Some states can, some states can't. But we leave it to you, to your conscience and to your sentiment and to your perception. But we have it in the DPSP. UCC, Uttarakhand did whatever they did. Yes? But that will be settled in the courts. But UCC being a DPSP helps. Now, DPSP's tremendous action has been taken. Be it how many welfare schemes you got, 10 kg of grain coming to you free per person per month. Yes, that's a DPSP. Food security, health is a DPSP. And Arogya Setu and all these insurance schemes are there. Pradhan Mantri Arogya program, Jan Arogya. That is
Ayushman Bharat.
Ayushman Bharat is health. All the reservation, all that you have, Article 46. But then I think you implied, why can't we shift the DPSPs into fundamental rights? I think that is what, if you allow me to take, read this into your question.
Right, sir.
We've been doing it, right to work. Your Mahatma Gandhi National Rural Employment Guarantee Act is taken out of Article 41, right to work. And then you got your right to education given to everyone in India, including non-citizens, 86th Amendment Act, 2002. That is, it used to languish as a right to primary education, Article 45, shifted that to Article 21A, replaced that with early childhood care and education. And I'll take the spirit of your question a little more forward.
Done, sir.
This early childhood care and education, if you convert that into, bring that into Article 15 to take care of children, every child has a right. A citizen, non-citizen also. Early childhood care and education and right to primary education, they are organically linked. Take care of the kid till he is 6, after that put him in school and you have continuation. So if you are saying 45, you convert that into 15 something or 21 something, then I'm 100% with you that it is long overdue. India has the money. We are the fastest growing major economy in the world. Tax collections are booming. IT booming, GST booming. You got enough money. The whole world is in a queue to lend to you. Take money. Make sure the foundation of society is taken care of in every conceivable way before they step into the school. Yeah, I agree with you. Yes.
Right, sir. That's something. When you put it as an example, it just gives you a glimpse of what could be the potential when we do this. So, coming back to one more very basic question, and this is in light of what I have been teaching in my PSIR optional, that India has always been a duty-centric nation, right? When we talk about dharma or dhamma. But then in the modern times, we went towards the rights. And in our constitution, we have made the fundamental rights protected by the court. But we haven't done the same with the fundamental duties. Even though the word fundamental has been added, it is non-justiciable. So what is this balance between rights and duty? And is it time to make the fundamental duties justiciable or enforceable at least?
See, we know what is a right, we know what is a duty. Right is a claim on the state.
Right.
It is legally recognized. And without rights, we cannot survive. For example, you and I are discussing today because we got the right 19(1)(a). And without that, we will be suffocated. And all else. So, rights are crucial for democracy. They are a modern version flowing out of rule of law and constitutionalism. Duty is associated with socialist constitutions. For example, we borrowed on the recommendations of Sriram Singh Committee in 1976 fundamental duties from USSR, ex-USSR constitution. Duties are what makes the country strong. If you see the 11 duties, you have respecting symbols all the way down to having to send your kids to school. If you see the rights you have across the board, starting from 14 till 35 you have, and 12 being definition. Rights are, you can detect an element of selfishness in rights. That is, my right is for me, for the society. Right to property, okay, I run a business with that, lots and lots of people are coming up in life, but essentially it's my business, right to property. Everyone has a right to property. All the people who own the shares of Reliance, fine, but Reliance is essentially Ambani Enterprise. So right to property, like every other right, has an element of selfishness about it. Duty is selfless. You have to contribute to the society, at one level. Duties cannot be enforced. How can you enforce scientific spirit? I believe in God. You think science is against God, and are you going to imprison me because I have faith in God? You can't. And how will you detect if I respect women or not? How will you detect if I respect the composite culture or not? And what does it mean to contribute to the environmental stability? So these are all a bit nebulous. So duties by definition cannot be enforced. But you have concurrent laws which make them enforceable. For example, try not giving women adequate respect and it's a cognizable offense. The police officer will pick you up. So duties are tangible even while appearing to be intangible. Animals, try and be cruel to animals, you land up in the jail. Don't send your kids. There will be some pressure. There will be some pressure on you. And in Maharashtra, they have got some laws against superstition. And if you follow superstitions, then it's possible that life won't be easy for you. So there are many, many laws, which, for example, about, Asim Trivedi case, he trivialized our emblem, Ashoka Chakra, and the state got back on him. Yes? So, there are laws. which ensure that your duties are performed. But duty per se is not justiciable because it can create so much of litigation, so much of harassment. And for primary reason that it is in informal language vague. Now, you want that made justiciable. It can't be. But laws can be made. Actually, this question came in the prelim that there are concurrent laws to ensure that the duties are respected. If you ask me, can we have more duties included? For example, you were talking about population control. I would like a few duties incorporated. For example, the duty of voting as a duty, not as compulsory voting of Australia. You could incorporate. The duty of being tax compliant, you could. And if you ask me, can we change the preamble to insert a new word? I would like environmental justice. Justice, social, political, economic and environmental justice inserted into that. I'm sure people in power are watching and I'm sure they'll take the cue and they'll amend the constitution, not just to delete 2 words, but to induct a new word, which is 21st century word.
Sir.
Yeah, duties can't be made justiciable. It just can't be, but there is a backup to that. And rights, yeah. And I think that was your question.
Yes, sir.
They're complementary. And one more thing, in Asia, particularly in India, we are a dharma-driven society, duty-driven society. We want stability, let equality go to hell. We want stability, discipline, obedience, conflict-free society, all that. But scan the duties that you have in Article 51A, Part 4A. In the discharge of your duties, unless you have rights, you cannot fulfill your duties. Unless you give me Article 21A, the 11th fundamental duty is in a void. Isn't it? Unless I have the right to clean surroundings, what's my inspiration to contribute to environmental stability as a fundamental duty? Unless you call an animal a person in Article 21, how am I inspired to eliminate cruelty to animals? So they are intertwined. Discharge of duties requires that you have rights. Without that, you are paralyzed.
Right, sir. Now, let us come to another part of the Constitution, which is about the institution, the government, the 3 pillars, the legislative, executive and the judiciary. One of the core sentences that all students write is that the Constitution ensures checks and balances between these institutions. So could you elaborate on these checks and balances? Because in one way, we know that one controls the other, but we also know that one of the pillar has more power. How is then the checks and balances being ensured?
You see, Montesquieu, separation of powers, all institutions, the 3 institutions, if you can separate them and invest them with specialized functions, then for reasons of wisdom and for reasons of checking and balancing. So, the other day, the governor, executive of Tamil Nadu, sat on the bills as if it's a private matter. People waited and waited and waited, and finally they had no choice but to go to the Supreme Court. And remember, Article 361 doesn't give you the power to issue a writ of mandamus to the governor or the president. But nobody issued a writ of mandamus. I take my hat off to the wisdom of the Supreme Court. I get goosebumps when I recall what the Supreme Court did. Honestly speaking, very honestly. What did they do? Look at the extraordinary wisdom and the relevance of what they did. If you don't give your assent within XYZ period, we deem the bill passed that you gave. Who told you to pass it? We are passing it. That's a norm. For example, applying for UPSC after the 30th of June, you can't. So, you can't do anything. 1 month passed. So, the bill is deemed passed. 3 months passed. That they took it to the presidential power under Article 111 also. President of India being set a timeline beyond which the power slips out of his jurisdiction. Never heard of anything like this. So this is an example of check and balance. The executive is delaying. Judiciary is checking the delay to ensure people's will prevails. Parliament is left, right and center amending the constitution, distorting the essence of the constitution. Keshavananda Bharati, basic structure. So the three organs with their respective functions, they are drawn boundaries, and if they cross the boundaries, one of the other two, lastly the Supreme Court. Supreme Court, what's happening to two judges? They are accused of having sort of, exhibited proved misbehavior. Proving they will do. So if there is judicial, quote unquote, these are strong words, misconduct. They are not my words, I'm quoting from the law. So judicial misbehavior, let there be a committee prompted into action by the initiative of the legislature, Rajya Sabha or Lok Sabha. There are rules for that, Inquiry Act 68. Let them investigate. Ask the Honorable Judge, come and defend yourself, either personally or by a lawyer. And if you are convinced, we'll let you go. Otherwise, we'll nail you. Pass Parliament, this, that. So you are holding the judges accountable. You have all the power in the world, but you are accountable. Autonomy is not immunity, not much less impunity. So legislature is checking the judiciary. Judiciary is checking the executive. Pass a bill and let the president take it up, and the president can delay it for a bit of time. Check and balance. What did Abdul Kalam do? So unless you check and balance, our liberties are not safe. That's why they would say, if the judiciary is disagreeing with others, you think there's a conflict, acrimony, and then breakdown? No. If they are friends, we had it. Let them quarrel, and we are all very safe, isn't it? So, checking and balancing is very, very important. Most unfortunately, yesterday, the Supreme Court of US told every court in USA, whatever our Honorable President does, don't come in his way. This is not checking and balancing, this is imbalancing. And wherever it goes here on, we'll see.
Right, sir. So, but sometimes it is then said that it is a case of judicial overreach, judicial activism, as the Vice President had said, that this is like giving a timeline, setting a timeline for an assent or dissent of a bill by the governor or the president is definitely where the judiciary is going overboard than what has been given as its power. Do you think, sir, that's a case of judicial overreach then?
At times they overreach because they are over enthusiastic about ensuring constitution is respected in letter and spirit at times. But the case you were quoting, Tamil Nadu government versus Tamil Nadu governor, that in my ultra humble view is not overreach because somebody had to bell the cat. Somebody had to tell the executive that you are embedded in a parliamentary democracy and your enthusiasm about checking the legislature is wonderful, but don't overdo it. So if there's overreach on the other side, somebody has to bring back within the boundary. So judiciary has done it, and prescribing a collegium for the appointment of the chief election commissioner and Anu Baranwal case. Even that also, in my view, it is not overreach because they were saying we are indicating the composition of the collegium. You compose it the way you like. After that, it will come to us. We'll see. Collegium is important because everyone looks up to the chief election, the election commission, free and fair election. So, erring on the right side is what I call the judicial overreach. Except once in a blue moon, they don't overreach, which is regrettable and which is reversible. They did. They were telling people, don't sell liquor within a radius of 500 meters from the highway. Yeah? Then you change the name of the highway and start selling, which is what Punjab government did. And people were saying, what is a highway unless you are high? So don't bring yourself to a point where what you say becomes laughable and you will yourself have to recall it.
Right, sir. Right.
That's once in a blue moon.
Done, sir. Coming back to judicial overreach, the another debate that has been going on is about the basic structure doctrine, wherein again our Vice President has been talking about the fact that why does the judiciary have the power to decide the pillars of the constitution as the basic structure? Why can't the parliament or the legislature or the executive be part of that decision? In that light, sir, again, is it A, overreach, B, is the basic structure and a limitation on the parliamentary democracy?
See, parliamentary democracy is one of the features of basic structure, so it can't be a limitation, point number one. You can't say parliament is supreme, we are the elected people. That will be sovereignty of parliament, which is not something that the constitution has made the parliament. In Britain, in a way, Parliament is sovereign. In India, Parliament has enormous power, but it's one of the three organs of the government subject to Constitution, which is subject to interpretation by the Supreme Court under all circumstances. Now, Keshavananda, who gave you the power? They have the inherent power that the guardians of the Constitution, the oath they take is to protect the Constitution. So, the oath they take, number one, inherent power, number two, Article 142, number three, their job is to protect the Constitution, and if the Parliament is invading the Constitution, to a point where it doesn't resemble what was drafted by the Assembly, then somebody has to once again bell the cat. And what did they do? They didn't harm anyone. These are the basic features. Okay, I'll give you an example. Preamble is a basic feature. Did you not amend it? When was Keshavananda? 73. When was the 42nd? 76. Did you not amend it? You can amend it. Go ahead, amend. GST, Federalism. Did you not do GST? You did GST because it enriches federalism. Bombay verdict of 94 said federalism is a basic feature. But you did so many things which are dealing with federalism, but you enriched it. You can enrich it. DPS, peace and fundamental rights, are locked in a complementary balance. Don't tilt it in either way. If you tilt it, you are violating the basic feature. But you do whatever else you like. But ensure there's a balance which is built on harmony. So, they didn't tie the hands of anyone. They respected the Parliament enormously. They ensured that the country is led in the proper way as envisaged by the constitutional morality, the spirit of the Constitution, the values that the Constitution stands for. Judiciary will not let them be distorted for the partisan gains, personal gains. After all, what are people saying? Indira Gandhi distorted because she wanted to survive. Here on, it will not happen. Yeah.
Right, sir. Coming to current politics right now. Two things that are going on, again, matter of debate. One is the Delimitation Commission. You've already referred to it, but this has become a discord between the northern and the southern states. In this light, sir, what are the constitutional implications of the proposed delimitation process? And could you just explain what this entire delimitation is going to be all about?
As the population increases, you have to create more constituencies so that the representative is able to represent that many people. 10 lakh, 15, 20, 25. How many people can you represent? 10 lakh? So, if at 500 constituencies you are able to represent 10 lakh, we'll make it 1,000 so that when the population reaches a billion, about 100 crore, whatever, we will make it 1,000 constituencies so that you are able to represent. No one is superhuman here. So, in 1951, you delimited. 61 expanded, 71 expanded. Suddenly we realized at this rate, if you go on expanding, some states are getting more seats, and some who are a little more committed to stabilization, they are losing out. So by that's 2080, there will be demographic equilibrium. The census after that is 2001. Based on that, we will expand the number. That was the 42nd Amendment Act. That's because, democracy cannot be an enemy of federalism and vice versa. They have to be carried forward together. But then country did not stabilize demographically in 2001, yes. But then you had to redraw without expanding the numbers, so that outer Delhi, 33 lakh people, Lakshadweep, less than one, a few lakhs or whatever, less than, actually it could be in thousands also. Chandni Chowk is 6 lakhs, outer Delhi 33 lakhs. Same person. So one vote, one citizen, one vote, one value broken, isn't it? So Kuldeep Singh Commission, Parliament made a law, Delimitation Commission, headed by the Honorable ex-Justice Kuldeep Singh. And one side is the election commissioner, state election commissioner. 3 of you go, do it. It takes a few years. They did it. And based on that, 84th and 87th Amendment Acts ensured that redrawn, but not the renumbering. 543 remained 543. But SC/ST got expanded because Constitution promises to them. After that, now, the census. And what did the 87th and what did the 84th say? They said The demographic stabilization of the country is going to be achieved in 2026. The census after that is 31. So the next renumbering, expansion of numbers will take place only after 31 census. Because we already are supposed to have, according to 87, 84, demographically stabilized by 26, the census of 27, that will be the basis for delimitation. Will that be accepted or not? I have no idea. But judiciary won't poke its nose, in every matter. They'll let you be. After all, it's your domain, you go ahead. We are not in the picture. Now, UP hits a jackpot because the number of people in UP are of continental dimension. Young people, they can develop the whole world, not just UP. Believe me, I come across people from UP, etc. Civilizational wealth that they exhibit, you have to take care of them. If you take care of them, they'll take care of the world. Net, they have the population. And poor Tamil Nadu, Telangana, Andhra, Kerala, they spent a lot of money on empowering women, health, decentralization, education. And once that happens, forget family size of more than 3 or 4. So now the net effect of all this is, if you are going to ensure one voter, one vote, one value, all that, then UP will have so many more. And Tamil Nadu will ask, developing the state, have we committed an offense? Why should we be losing? So democracy favors UP. And if you give UP, Bihar, the number of seats they deserve because of the population they have, Lok Sabha will have UP Sabha. Yes? And assembly numbers also, UP will have far more, Tamil Nadu will have less, UP will have far more in Rajya Sabha. So it's not Indian Parliament, it's UP Parliament. So, democracy justifies it, but federally, what will they feel? Making a law, the people who are more populous and by implication not very socially committed, this and that. So they are the ones who are making the law. And presidential election also, So they are saying, don't punish us for that. It's not that UP is not developed. Please get the nuance correct. UP deserves all the seats that its population prompts. But that doesn't mean Tamil Nadu should lose. So the ratio of today, respect it. Let Tamil Nadu have, let UP, 15 lakh people, let UP MP represent. Tamil Nadu, let it be 10 lakh. What's the problem? There's no problem. Let Tamil Nadu MP have 10. He is doing justice, little more justice. Let UP MP have 15 lakh voters or population. He is doing justice. So everyone is doing justice, but some people you are hand holding because they can't be penalized for the good things they have done. This is asymmetric federalism, which is another characteristic feature of our federalism. All states are not treated alike. You are Delhi, you got an assembly. I'm Chandigarh, I have none. Yes? He is UP, he is a state. You are Delhi, you are a UT. He is Maharashtra, he's got development boards. I'm Telangana, I've got locals, non-locals. He's Himachal Pradesh, you can't buy land there. Telangana, you can buy. So, asymmetric federalism, where the powers enjoyed by the states are not the same because we are a coming together. We are not a coming together federation, we are a holding together federation. You can work out a formula where all the states are happy. Some states don't lose out. You have respected democracy. You have respected federalism. Because ultimately, the future of the nation depends upon how states behave. You can't let them down and expect them to come up to the levels that the nation deserves.
So another debate is about the one nation, one election. It's an evolving federal dispute also. How would you see the way forward in this?
If the government believes 129 Constitution Amendment Bill introduced in December last year says we are spending too much money and election is going
on somewhere or the other. Prime Minister also goes there, his time is wasted, his national development is his preoccupation, a lot of money is wasted, model code of conduct kicks in, policy paralysis, and too much of politics and no economics and development. So let us have one nation, one election. That's the goal. But some people are saying that you mix up the priorities for states assembly election, I want you in my assembly because you've done tremendous work. You belong to XYZ party. He belongs to ABC party, and I want him in the Lok Sabha because he is good in dealing with inflation, national security, unemployment. Issues are different, but if you combine the elections, then people will be confused, and therefore let's not do it. Point number one. Point number two, after 2 years, if there is a breakdown of the government, then you will have to go for elections in the assembly, and the remainder of the term is only allowed for the assembly after the elections, and this is injustice and all. Actually, either way, it's okay. No one is being denied anything. Electorate is very, very smart. You go either way, but UPSC asked a question about 7-8 years back in the main exam, wherein they said that unless you have continuous elections, where is the accountability? The so-called populism is a blessing in disguise that the people of the country are handed out when there are elections. Yeah? So women get 1,500 rupees in their bank account. Elections are there. Reservation, elections are there. Loan mafia, elections are there. All good things in India have happened because of elections being there somewhere or the other all the time. So this continuous elections here or Bihar elections are coming. A lot of good things will happen. After the Tamil Nadu, a lot of good things will happen. So elections are a festival, elections are for celebration, elections are for accountability, and elections keep the government on toes. Yeah? So you don't see it that way. It's fine. I mean, that's another view. Yes.
So, but I'm going to come back to the asymmetric federalism, because what we are seeing currently is a strong or a very, very nuanced differences coming between the northern and the southern states. I'm not saying it was not there before, but it is now becoming on each and every issue, whether it's the language or whether it is culture, whether it is one nation, one election or delimitation. We are seeing that it is a very, again, an evolving federal conflict that is coming up. What could be the way forward in this case, especially in light of asymmetric federalism?
See, federalism in India is a fact of life. Power sharing, 7th schedule, finance commission, 131 article for the Supreme Court, interstate councils, zonal councils. They're all federalism. Even the regional councils allowed under the charter of the Niti Aayog, they're all federalism. But federalism, much as you cooperate, like one of the verdicts was there, Mohit Minerals case, that was in 2022, uncooperative federalism. What is uncooperative? It's not that we are cooperating on everything that the center is proposing. You are Tamil Nadu and you don't agree with the center, you don't give permission to CBI, general consent you don't give. They are still able to come into your state and investigate case by case basis. And you pass a resolution saying that we don't agree with what the central government is doing. So, uncooperative federalism is also a part of the federal dynamic. Now, federalism, the way the state relations work, who is more powerful, are they working together, sharing power, or is it centralizing or decentralizing? That's a function of the larger political system. When you see, people say that for the first 3 general elections, you had the center, the Lok Sabha and assemblies going to the polls, but no one imposed it by law. No one enforced it by law. It's just that the cycle coincided and there was no opposition to Congress. 67 onwards, there was opposition, and you've not seen simultaneous elections since then. Now, a fiscal federalism, education being shifted into the concurrent list. I'll not give you money unless you have 3-language formula. These are the small bickerings every federation will have. We have not come together, so there will be some asymmetry. After all, Maharashtra, you have Assam, Meghalaya, Tripura, Mizoram. Tribal governance requires that they have the 6th schedule. Everyone accepts it. Finance Commission, UP has to get more money because people are there. Who is disagreeing? South is disagreeing. If population is the basis for devolution of money, then let's populate. So there is a perverse effect to that. We are a dynamic democracy, little noisy. So these issues are bound to come up. But how is foreign direct investment coming up? We are enormously successful democracy. North to south, I don't see it that way at all. I see it as the troubles, the challenges associated with development. In a huge country like ours, sitting on 1.45 billion people, I don't see it. I see regional development imbalances. I don't see north and Punjab is not south. Punjab is fighting with the center, and Bengal is not south. They are fighting with the center. Odisha till the other day they fought, and they are not south. And not everyone is fighting with the center in the south. Karnataka is happy. AP is happy. So north-south is too broad and sweeping a way to see development in geographical terms.
So, one more debate that I would want to focus on is about the presidential rule. So, again, let's start from the basics. What is the president's rule, and why is it seen as a tool, a political tool, sometimes leveraged by the executive? Especially in light of the crisis going on in India, especially in the northeast.
So northeast, there is only one state under president's rule.
That's
And they should have had it long time back, because the trouble there is such that constitutionally elected government broke down. So if the constitutionally elected government breaks down, there is no alternative to that. How will you fill the void? You need to have power exercised by somebody. Who will exercise? Only the central government. It can't be the governor. Governor via the central government. But your question basically is taking the discussion into, is it being abused? 130 times president's rule. I'm sure more than 100 times it's been abused. I come from Andhra. I remember N.T. Ramarao with huge mandate. He comes and somebody here tells the governor there, dismiss him, create a split. Split. Not even a split, a fringe goes away, and then you dismiss him, and then of course he's been restored because there is a lot of civil society action. So basically, the vulnerability of the governor to the orders of the union government for a variety of constitutional provisions, that ensures that he behaves as the central government directs him. And inter-party conflicts found Article 356. The union government found a convenient tool with 356 to dismiss the government that didn't agree with it. But that was only till 1991. After that, coalition government started, which is you are from Tamil Nadu, you are DMK. Earlier, I didn't want you to exist, so I was dismissing you. Now, without you, I'm not there. Together, we have to form the government. And by then, Bommai also, the verdict came in 94. And in 98, K.R. Narayanan told Vajpayee ji, you want me to dismiss Lalu government, but what is the objective basis for it? Please reconsider. Are you sure you will get some support in Rajya Sabha? So please give a thought to all this. After that, under Article 74, you still are convinced that I should dismiss, I'll dismiss. I'm constitution bound, as well as I've got a little bit of discretion under 74 as it emerges after the 44th Amendment Act. So please give it a second thought. So you see, K.R. Narayanan ji, then coalition government, Bommai, all of them ensured that the president's rule is not resorted to for partisan gains. That's working. But for the last 10 years, you've got one party rule. Even initially, they had, sort of used it not so well, Uttarakhand, Arunachal Pradesh and so on. But now I see single state under president's rule, which is hats off to the vibrancy of the democracy, our federalism. So only one state. Basically, Article 355 gives the union government a duty to ensure that state is governed well, defended from external aggression, and also ensuring internal disturbance, not armed rebellion, internal disturbance. So in case they have to dismiss the government and have president's rule to ensure that constitutional governance prevails, they can do it. That is a constitutional norm. But I think the very first question that you had posed about rewriting the constitution, you need to, the institution of governor and Article 356, they require a second look so that they're rendered foolproof. Yeah.
Right, sir. So let me come to my last question now. Rather than having these piecemeal amendments going on one after the other, would it be prudent enough to have a new amendment or a revision of the existing amendment? In light of a debate going on that this particular constitution has certain loopholes. And it is time to address, especially in the light of these challenges, that a new constitution relevant for today should be discussed upon.
See, this question could have been asked about 3-4 decades back. Now that you amended the constitution 106 times, now that there's tremendous amount of constitutional law by the Supreme Court and here and there by the High Courts also, we are as good a constitution as you're dreaming of. What do you lack in the current constitution? Governor, there was room for improvement. Supreme Court stepped in and did it early this year. And I don't see any room. Fundamental rights, etc. We're fully packed and they are working well. But here and there, wherever you need to amend the constitution, we already discussed it. Early childhood care and education, from 45, bring it into 15 or 21. Point number 1. Point number 2, clarify about 50%. When does it apply? This and that. Point number 3, strengthen the institution of governors so that, according to Supreme Court, is an independent constitutional office. Let him function as an independent constitutional office. Preamble, amend it and bring it in environmental justice along with socio-political, economic. So rewriting, there is no need at all. In fact, 25 years back, the NCRWC under Shri Venkatachalaya ji, they said there is no need to rewrite. We are working well, we are evolving well, as a living constitution, and so let it evolve. Yeah.
So thank you so much. And thank you so much to all our audience. With this, we wrap up today's discussion. I really hope that you have enjoyed the discussion the way I have, the punchlines and the clarity with what, the basics were discussed by Sir. I really hope it has given that foundation, especially when you're studying certain books that are available or you're preparing for any exam. These are the basics that you need. Even if you are, watching a traditional media or being part, of the social media discussions, basics of these words, the core fundamental of these words is important to understand. And I hope today's discussion helped you in that. With this, let me take an adieu from all of you. Till next one, bye.